Hello everyone and welcome to today's Mondac webinar in association with McCarthy Tétrault, who will be discussing the current and emerging developments, trends and news in labour and employment law, immigration and human resources practices from Canada. My name is Dan Sampaio and I'm joined by a brilliant panel to take us through today's discussion. But before I hand you over, a quick housekeeping item. You can submit questions to our panel by typing them into the questions pane of the toolbar on the right-hand side of your page. We do encourage you to get those questions in. It's now my pleasure to hand you over to Tim Lawson to begin. Thank you.
Thank you, Dan. Thanks for that kind introduction. Welcome, everyone. Thanks for signing up and spending the next hour with our group. This is a continuation, really, of a series of webinars that we're doing in partnership with MONDAC, covering a whole variety of labor and employment issues, statutory changes in Canada. Each webinar can't, of course, cover every single issue, so we're trying to kind of space out the issues over time through these webinars and deal with ones that are very topical, ones that our clients are very interested in. And so hopefully, if you listen to the series, you'll get a really good kind of overview of a lot of the issues that we deal with on a regular basis as Canadian labour and employment lawyers in this space, which covers, of course, human rights and occupational health and safety, and wrongful dismissal law, equity, workers' compensation, the full gambit of labour and employment work that we do as a national labour employment group at McCarthy Tétrault within a larger full service firm. So if you haven't looked at our website, just quick plug for the firm. Look at it. We have a lot of material on our website around these issues. We have blogs, we have webinars as well, independent of the ones we do with MONDAC. But the MONDAC ones are our favorite. So we're here to talk about, for the next hour, a bunch of different issues with our panelists, and I'm very happy that we have today quite a large panel. We've got six lawyers from the group. That's Sarah Hickey from British Columbia, Chris Botcher from Alberta. From Ontario, we have Marco Fimiani. We've got Sarah Adler. In our immigration group, we have Jessica Rudler. In Quebec, we have Emily Thibault. And my name is Tim Lawson. I head up our National Employment and Labour Group, and I'm very pleased that we're able to bring six panelists and a whole bunch of topics to you today. So, sort of without further ado, why don't we go right into it, and we'll talk about our agenda. So these are really the four things we're going to cover today. We're going to talk about pay transparency and equity. So this is a really hot topic, not only in Canada, but in the U.S. and in Europe and elsewhere. Our second topic, updates in case law. So we're gonna kind of expose a whole bunch of different cases, which are all very topical, very recent, and things that you as labor employment lawyers or human rights professionals will be interested in. Immigration law, very topical issue here in Canada. If you've been reading any of our national papers, it's a real election issue coming up in October. So Sarah's here to tell you a little bit about that. And I was going to say we're going to have a Q&A at the end, but what I'd rather do is take some questions during the course of the webinar. There's a chat line. There's a lot of people that are on this that are listening in, so I can't promise that we'll get to your question. But if you do have a question, briefly just put it in the chat, and perhaps I'll be able to kind of weave it into the panelist discussion. So I'm going to turn it right over to the first topic, and Sarah Hickey from British Columbia.
Hi, everyone, and thanks for being with us today. As Tim mentioned, my name is Sarah Hickey. I'm based in British Columbia, so I'm going to talk to you briefly about some new pay transparency legislation that's come into force recently in British Columbia. So the BC Pay Transparency Act passed into law in May of 2023, so just last year. And this new legislation puts new requirements on BC employers to address pay discrimination in the workplace. So this slide and my presentation today is just supposed to be a high-level overview, just to hit kind of the key new requirements with this, this new legislation. But one key new obligation that many employers are interested in and concerned about is that employers who meet the definition of a reporting employer as defined under this new legislation are required to complete and post a pay transparency report relating to all of their BC employees by November 1st of each year. So a question we get often is, what is a reporting employer? And the definition in the legislation creates a staggered start in capturing companies under this definition based on the number of employees that the company has as of January 1st of a year. So unless exempted by regulation, an employer that has the following number of employees on January 1st would be a reporting employer for the applicable year. So for 2024, it's employers with 1,000 or more employees. For 2025, it's employers with 300 or more employees. For 2026, it's employers with 50 or more employees. And for any year after 2026, it's going to be more than the lesser of 49 employees or another number set by regulation. So although the reporting employer definition is only capturing the biggest companies in BC at the moment, in the future and future years, it will capture many more employers. And so this number is based on the number of employees that a company has in BC that has been clarified. So while your company may not be captured under the reporting employer definition at the moment, the following other obligations are currently in force already and apply to all employers in BC. So as a result of this new legislation, employers are now required to include the expected pay or the expected pay range in publicly advertised job opportunities in BC. Employers are also prohibited from asking job applicants about what they have been paid in prior positions as part of an interview process. So you're no longer allowed to ask about an employee's pay history. And employers are also prohibited from taking certain reprisals against an employee. So for example, because the employee asked about their pay, revealed their pay to another employee, asked their employer about their pay transparency report, asked the employer to comply with the Pay Transparency Act, or if the employee makes a report to the Director of Pay Transparency in relation to the employer's compliance. And those prohibited reprisals may include terminating an employee, disciplining them, suspending them, or harassing them as a result of this behavior. So these are some of the key new obligations. And of course, with new legislation, sometimes, you know, we're still waiting to receive further guidance on how these new obligations will be interpreted. And so luckily, recently, the government of BC published some new guidances to assist with the interpretation of the Pay Transparency Act. As a reminder, guidances are often non-binding, but they can be helpful in employers understanding their obligations under new legislation. So there's a new guidance on wage and salary information on job postings. So that guidance includes some examples on what's okay and what's not okay to include in job postings in BC. And then a much anticipated guidance that has recently been posted is a new guidance for preparing pay transparency reports. So this new guidance works hand in hand with a regulation that came out under the Pay Transparency Act called the Pay Transparency Regulation, and includes information about what information actually needs to be included in these pay transparency reports when an employer does become a reporting employer. So speaking briefly on generally what will be required to be included, employers will be required to include certain information about an employee's pay as compared to different gender categories among their workforce. So some examples of the information that's required to be included would include the percentage of employees in each gender category who received overtime pay in a certain reporting period, the percentage of employees in each gender category who received bonus pay, the difference in median hourly pay, overtime pay, the number of overtime hours, and bonus pay. And then there will also be a requirement to show in the pay transparency report the proportion of each gender in each pay quarter. So employers will need to rank employees from the lowest to highest pay and identify how many of each gender are in each quartile. So although this this does sound onerous and intensive for employers to have to do. Luckily, the government of BC recently announced that they are preparing a new tool to assist employers in preparing these pay transparency reports. So we're really looking forward to seeing this tool, and hopefully it will assist in employers meeting their obligations under this legislation. So pretty interesting legislation. We're still seeing how it rolls out, but it's definitely changed the landscape in BC with respect to pay transparency. Thank you.
Thank you, Sarah. Sarah, one question that just came up is are those guidelines available online somewhere?
Yes, so they should be available on the BC provincial government's online website. But, you know, when I was looking at them to prepare for this presentation, I was able to just, you know, put in Google guidance for preparing pay transparency reports and guidance on wage or salary information on job postings. But the government has prepared a full website about pay transparency, so they're just available there.
Perfect. Thank you. Okay, great.
Thank you.
So I guess we move on to Jessica.
Yeah, thanks, Tim. Good morning, everyone. As Tim mentioned, my name is Jessica Workler, and I'm located in Ontario, in Toronto. So I'll be chatting with you this morning about Ontario's Pay Transparency Act, and that was enacted in 2018. However, it was actually not brought into force following the change of government. So if it is ever brought into force, just really quickly, the Act will require employers with more than 100 employees to collect information and prepare transparency reports. There's also a couple other interesting parts of the Act. So there's reports that may be published on the internet by the Ministry of Labour, and also information identifying contraveners and penalties that could be published by the ministry if that act ever does in fact come into force. That being said, there is a recent legislative change that happened on March 21st, 2024, and that was the Working for Workers For Act 2024, Bill 149, which received royal assent. And Bill 149 amends the Ontario Employment Standards Act to include a new section actually pertaining to job postings and requirement to address pay transparency provisions in job postings. And so with the passing of the Act, there was a couple different sections that came into force right away. So we'll chat about those in a couple minutes. There are some that come into force on June 21st of this year, and then some that are not currently in force and that will take effect in the future. So let's chat about those that are in force now. So now, with the passing of Bill 149, they have changed the definition of employee to confirm that work performed in a trial period is considered training. And as such, any person performing work in a trial period is considered to be an employee for the purposes of the Employment Standards Act. Currently, the employer cannot make a deduction from wages because an employee has a cash shortage or a loss of property. And as a result of Bill 149 now, expressly includes where a customer or restaurant or gas station or other establishment leaves the establishment without paying for goods or services taken from or consumed or received at the establishment. You cannot make a deduction from wages as a result of that potential loss. So the key changes, those have taken effect, and key changes that will occur on June 21st of this year include if an employer has a tip policy where the employer or director or shareholder shares a tip pool, the policy must be in writing and posted in the workplace, and it has to be retained for 3 years. Amendments will also be made to vacation pay provisions to clarify and confirm that any permissible alternate pay arrangement agreed to between the employer and employee must be in writing. And there's also an amendment that will come into effect to clarify that if payment is made by direct deposit, in addition to being in the employee's name and being accessible only to the employee or a person authorized by the employee, the account must be one selected by the employee. And the changes that are not currently in force and will take effect in the future on proclamation have to do with pay transparency. And so that kind of brings us back to the issue of pay transparency. And so when these are you know, when they do actually come into effect, an employer will have to include information about the expected compensation for a position or range of expected compensation in any publicly available job posting. So that's not in effect now, but that will, you know, come into effect upon proclamation. So something to kind of keep your awareness about once that is passed. An employer cannot include any requirement related to Canadian job experience in a publicly available job posting either. And an employer will have to disclose any publicly available job posting if it uses artificial intelligence to screen, assess, or select applicants. So those are the key pieces that will come into effect at some point in the future, Tim. So we'll just move on to the next slide.
Thanks, Jessica. Good morning, everyone. So just here to talk a bit about pay equity and what pay equity actually is in Canada. And so what it is really equal pay for work of equal value, with the premise being that where two different jobs provide equal value to an employer's operations, and those two jobs should receive the same pay. And so what can sometimes be confusing about pay equity is that it's like comparing apples to oranges, and it's not like comparing apples to apples. And what I mean by that is pay equity is not about comparing the pay of similar jobs where men and women are doing the same work. So for example, comparing a female truck mechanic's pay to a male truck mechanic's pay. This is an example on the Canadian Human Rights Commission's website in connection with pay equity. But rather it's actually about comparing the value of a truck mechanic job class, which is typically a job class commonly held by men, to that of an account technician, which would be considered a job class commonly held by women. And so that's where the apples to oranges analysis is really what you're looking at. And so every Canadian jurisdiction actually has pay equity legislation, but with the exception of the federal sector as well as the Ontario and Quebec, those are the only three that really have it apply to private sector employers as well as public sector employers. And so at the federal level, the final version of pay equity plans for those who were subject to the Pay Equity Act as of August 31st, 2021 are actually due later this year on September 3rd, 2024. And what happened once those pay equity plans are posted is that employers must then correct any identified pay equity discrepancies, and depending on how much of an increase might actually be applicable, employers are permitted under the federal regime to phase in the increase over a number of years. And so just something to be mindful of for federal sector employers who are already probably alive to this, is there was a number of processes and steps that had to take place between inception of the act in August 31st, 2021, and now, including in some cases, depending on the size of the employer, implementing a pay equity committee, drafts of the plans, providing a notice, just something to be mindful of as the next phase of compliance with that legislation actually takes place. And so with that, I think we can move to the next slide.
Okay, thanks, Marco. So that's a quick summary on pay equity and pay transparency. Often confused, but connected. But I think Marco's point's a very good one, which is from a pay equity perspective. There's two provinces and the federal sector which has pay equity, but the rest don't. And obviously pay transparency acts are not yet very common in Canada, but probably there'll be a push to continue implementing those on a province by province basis. So it's important to understand, from your employers, from your organization, whether you're a provincially regulated entity or whether you're federally regulated, because it's important which jurisdiction you land in, because from an employment labor perspective, only provincial laws apply to provincially regulated employers. Federal, same thing. So it's not like in the US where you've got a multitude of federal, state, even municipal laws that all have some impact on an employer that resides in each individual state. Okay, so moving on to case updates. This is always the exciting things. Now we're not bringing you obviously the outlier cases. These are important cases. They're topical, and we're bringing a selection of them to you. So I'll go back to Sarah for a couple of cases in the BC courts.
Hi everyone again, and so I'm here to talk to you about a recent interesting case that just came out of the BC Court of Appeal this year, and it's quite relevant because it is a case that talks about the law of frustration in BC in the context of employment contracts. So in this case, the employer ran a duty-free shop in Aldergrove at the US border. So it was a shop right at the border that serviced travelers who were crossing across the border. And it was a small family-owned business. 99% of customers were holiday or vacation travelers crossing the border. However, as we all remember, in March of 2020, the COVID pandemic occurred, and the land border between Canada and the US was closed to all non-essential travelers because of the pandemic. So as you can imagine, this drastically impacted this small shop that was reliant on travelers. And so as a result, the employer temporarily laid off all of its employees, including a 78-year-old employee who was the plaintiff in this action, who worked as a retail sales clerk and had worked at the duty-free shop since 2010. So initially, the employer under the BC ESA put all the employees on a temporary layoff, but after a certain period of time, by operation of law, when the employer did not return the employee to employment, that layoff converted into a termination. So the shop remained closed until November of 2021, and the land border reopened. However, the employer refused to rehire or pay severance to the employee. So the employer claimed that the contract had been frustrated by a supervening event, otherwise known as the COVID and the fact that the land border had closed. And so the employee took action against the employer and started a lawsuit claiming that she had been wrongfully dismissed. So at trial, the BC Supreme Court, and I won't go too much into the trial decision because this decision was the one on appeal, but at trial, the BC Supreme Court judge sided with the employee and found that the employee had rejected the appellant's. So the BC Supreme Court found that the employee had been wrongfully dismissed and that her employment had not been frustrated, and she was awarded 10 months of salary. So the employer wasn't too happy about this and so appealed to the BC Supreme Court. And so the BC Supreme Court dismissed the appeal, finding that the employment contract had in fact not been frustrated. And so the BC Supreme Court made a few key findings about frustration, which have developed the law with respect to frustration in the COVID context. So to understand what frustration is, there's a key legal test to establish frustration of contract. And so the legal test for frustration is often referred to as the radical change in obligation test. And so to establish frustration of contract, 3 things must be established. The first is a qualifying supervening event that was not contemplated by the parties when they entered into the contract initially. The second is that the supervening event is not the fault of either party. And third is that the supervening event renders performance of the contract something radically different than what was originally undertaken. And so the court found that the COVID border closure did not qualify as a supervening event. And so the court said that the border closure due to COVID did not make it impossible for the employer to perform its obligations under the employment contract. The main issue for the employer was economic, so it was their economic viability. The primary obligation under the employment contract was for the employer to provide an hourly wage to the employee to attend at the shop, to perform retail sales, and to perform janitorial work. And the court said, well, the employer is actually still able to perform this obligation, even though the border is closed. It's just not, economically viable for them to do so, but it's still possible. And so the court strongly rejected the employer's argument that it was a term of the employment contract that the shop would maintain a certain level of customers, work, or business. The court commented that business would likely ebb and flow in any case, even when the border was open, and noted that if they had accepted this argument that a downturn in customers rendered a frustration of contract, this could open the floodgates and make that defense available every time a retail operation experiences a reduction in customers. So the key takeaway, in my view, from this case is that if an employer plans to take the position that an employment contract has been frustrated, economic factors alone will probably not be enough to establish frustration of contract. And this has been upheld now in this case, in the case of even a border closure with a business highly reliant on border traffic. So economic factors are likely not sufficient to maintain a frustration defense. I think I can go to the next slide. And so another case I'm going to briefly talk to you about today is the case of Sandahar Trucking Limited versus Sandu. So this is a case that came out of the BC Civil Resolution Tribunal, which is a tribunal in BC for smaller matters, although the tribunal made some very relevant findings relating to time theft, which I would like to talk to you about today. So this case involved a dispute between an employer and an employee with respect to time theft. However, it was a relatively unusual case as the employer actually was the one to take action against the employee in this case. So the employer was a trucking company that started the action against their former employee, who was a former trucker. And the employer alleged that the employee had committed time theft by overstating the amount of time that they had worked by 153.5 hours. And so the employer had done an investigation into the employee's time and noticed some discrepancies with the employee's timesheet and determined that the employee had been overpaid. And as a result, the employer started an action against the employee to try to recover the overpayment for the time that the employer said that the employee had been paid for but had not actually worked. And so the key point in this case was that the employee is a trucker, and so a lot of the time tracking that the employer was doing on the employee's truck had to do with GPS tracking software, which was a key point in the employer's case. So the employer relied on GPS tracking software on the employee's truck to track when the employee started and stopped their vehicle. And based on this information, they were able to cross-reference the GPS tracking to the employee's actual time that the employee had recorded that they had worked, and noticed that, in their view, the employee had overstated the amount of time that they had worked. So this case is relevant because this is a case where the tribunal dismissed the employer's claims and made some comments about what evidence will be required to establish time theft. And so the tribunal noted that time theft refers to the practice of reporting to work or punching in, but when the employee does not actually start work until later or leaves work before punching out. Notably, the tribunal said that time theft, like other forms of workplace misconduct, can range from trivial to egregious. And so there's a big range in whether time theft will be serious enough to be considered serious misconduct, or it may just be considered more trivial. So employers have exclusive control over the payment of wages, which the tribunal said created a rebuttable presumption that the employee earns the wages that are paid by the employer. And so it's up to the employer to disprove that presumption. The tribunal analyzed the GPS tracking software and noted that it only verified when a driver started and turned off their engine. However, the tribunal found that a driver or truck driver must complete other tasks, including reporting to the yard, receiving and reviewing delivery assignments, planning the route, conducting pre-trip inspections, and other tasks. The GPS tracking software would not have captured all these additional tasks, and so the employer placed unreasonable reliance on the GPS tracking software in determining whether the employee had committed time theft. The tribunal also found the employer's calculations to be unreliable with respect to the employee's time, and noted in some cases that the calculations didn't make sense, or the employer had actually rounded down the employee's time rather than rounding up. So in the whole, the tribunal found that there was not sufficient evidence to find that the employee had committed time theft. And the key takeaway from this case, in my view, is that as an employer, if you plan to allege time theft or you suspect time theft, it's always important to ensure that you have the very best evidence and do a very thorough investigation before making an allegation against the employee. as the evidence will be analyzed very strictly if the matter does move forward to court. Thank you.
Thanks, Sarah. It's probably one of those cases where there was time theft. They just ultimately couldn't prove it on the data, right?
Yeah, I think that's the case. That's likely the case, and maybe not having strong enough policies in place. The employee was responsible for recording their own time, and it seemed like there wasn't a lot of oversight. So I guess another suggestion might be having strong policies in place with respect to punching in and punching out could also help avoid time theft issues.
Yeah, agreed. Thanks, Sarah. That's great. Okay, so let's move on. Chris, you've been waiting patiently in Alberta, and you've got a couple of cases you want to talk about. So let's start with the Gurso case.
Absolutely. So hello, everyone, and good morning from Alberta. As Tim mentioned, my name is Chris Botcher, and I'm a lawyer from our office in Calgary, Alberta. And I'm here to talk about some recent decisions which are sort of relevant to both employers in Alberta as well as Canada generally. So as Tim mentioned, the first decision is a decision from the Human Rights Tribunal of Alberta, wherein the tribunal considered 6 complaints brought by 3 separate complainants, and all against their former employer. And just as a bit of background, the Human Rights Tribunal is an administrative body under Alberta's human rights legislation who's empowered to make decisions respecting allegations of discrimination, which are brought under our Alberta Human Rights Act. So in this case, each complainant asserted that the respondent, their former boss, subjected them to gender-based discrimination and harassment in the course of their employment. Further, one of the complainants asserted that the respondent discriminated against her on the basis of a physical disability. And 2 of them asserted that the respondent engaged in retaliatory behavior by commencing civil claims against them in response to their human rights complaints. And so the tribunal found in favor of the complainants in essentially every aspect of this claim, finding, among other things, that all 3 complainants were repeatedly and persistently subjected to sexual harassment in the workplace, and that harassment amounted to gender-based discrimination. As some of the people on this call might be familiar, there was sort of a laundry list of allegations which were found to be upheld in this case. But as it relates to the harassment, some of them included referring to the complainants using sexually suggestive nicknames, making inappropriate comments on their dress and appearance, inappropriate touching, the making of repeated sexual advances, and among other things, in response to learning that one of the complainants was pregnant, advising that the complainant could either accept a demotion or resign from their employment. As it relates to the allegation of discrimination on the basis of physical disability, the tribunal found that one of the complainants had been discriminated on that basis when the employer, again their former boss, demanded information about a medical appointment that the employee had attended, as well as repeatedly pressured them for information respecting the medical condition underlying that appointment, and essentially intimate details regarding her medical conditions. And finally, the tribunal found that the employer had retaliated against 2 of the complainants when he commenced civil claims against them upon receiving their filed human rights complaints. Given the specific facts of this case, these conclusions by the tribunal are frankly not at all surprising. But what's really notable about this case is the decision's discussion and commentary regarding the appropriate remedy to compensate and to the complainants for the conduct of the respondent. And so, referencing a recent Court of Appeal decision from Alberta, the tribunal acknowledged that, sort of unlike other jurisdictions, there is no statutory cap or limit on the amount of damages for mental distress, injury, or loss of dignity flowing from discrimination in Alberta. And the tribunal further relied on that case for the proposition that damage awards for discrimination must be meaningful and adequate, and that awards that do not appropriately compensate risk minimizing the serious nature of discrimination and undermining the purpose of human rights legislation, both in Alberta and throughout Canada. Going further, the tribunal highlighted a number of recent decisions in Alberta courts, where the courts have acknowledged that general damage awards for discrimination have been historically modest, and I believe one case says extremely modest in Alberta. and that the tribunal's recent practice of awarding general damages for serious allegations in the range of $20,000 to $25,000 should not amount to an arbitrary cap or limit on the amount of damages that the tribunal can award. So the tribunal really ran with this commentary and these sort of suggestions from our courts, and in respect to one of the complainants, awarded $75,000 in general damages for discrimination, as well as a further $50,000 as it related to the retaliatory conduct. Another complainant received $30,000 in general damages for discrimination, as well as $25,000 with respect to the retaliatory conduct. And the final complainant was awarded $50,000 in general damages. And so just going back to that commentary about the previous practice of awarding damages in the $20,000 to $25,000 range, this is a significant step up. And the total general damages award in this case between the three complainants was $230,000. And that's in addition to further damages that were awarded to the complainants in respect of lost wages, because the discriminatory conduct in this case led to their respective resignations, as well as special damages as compensation for the legal fees and other fees incurred by two of the complainants in defending those civil claims that were brought against them. And so really what this decision does is it highlights the recent emphasis that both courts and tribunals in Alberta and throughout Canada have placed on utilizing meaningful, significant general damages awards as a tool to denounce discriminatory conduct and make it known broadly that such conduct is inappropriate and will not be condoned. And the decision further stands as a reminder that in Alberta, at least, there's no statutory cap on the general damages awarded by the Human Rights Tribunal, and that such awards are potentially likely to continue trending upwards as time passes.
And Chris, just a point of sort of highlighting here that these are damages awarded against the employer of the individual that was misbehaving.
It's actually kind of interesting in this case. The original respondent, and so the person or the entity named in this was the employer, but during the course of these complaints, before they got to tribunal, that employer was assigned into bankruptcy, and then the individual respondent, that being the CEO of the company, he was the direct shareholder and sole shareholder of the company, essentially the directing mind of the company. He was named as an individual respondent in the place of the company. And so at the end of the day, these damages were awarded against him in his individual capacity and not to the company.
Yeah. Wow. What a I was going to say interesting case, but you know, when we say the word interesting, that usually isn't a good thing for employers or senior executives. So okay, we'll keep this one in mind and see if it gets appealed. Hopefully it will be, at least on the issue of damages.
Mm-hmm. And we can go to the next slide. Thank you very much. And so this next decision is a labor arbitration decision respecting the for-cause termination of a railway employee following a positive urinalysis substance test. And so as just a touch of background, this is a federal arbitration decision, and so not specific to Alberta. And in this case, the employee was subject to an oral fluid test as well as a urinalysis test. The oral fluid test being a test that tests acute impairment, so actual impairment under the substance, and the urinalysis test something that tests sort of prolonged impairment and sort of residual impairment, among other things. And so the employee was subject to both of these tests after demonstrating behavior in the workplace that raised the suspicion of both his colleagues as well as his supervisors. Some of that behavior included agitation, a nervous shake, lack of focus, being extremely talkative and restless, and stating repeatedly that his head wasn't in the game. And after being informed of this employer's decision that they intended to test him for drugs and alcohol, the employee also attempted to leave the workplace and had to be stopped by the employer to submit to the test. And so in this case, the oral fluid test was negative for cannabis, However, the urinalysis test was positive at almost 8 times the limit set out in the company's policy. And so based off of these facts, the arbitrator considered 2 primary issues. First, was the testing of the employee in this case reasonable? And second, was there cause to terminate the employee's employment? And those sort of go hand in hand. On that first issue, whether the testing was reasonable, the arbitrator determined that the unusual signs and symptoms demonstrated by the employee were consistent with the residual impact of cannabis, and that in conjunction with the extreme safety sensitive nature of the workplace. Again, he was working actively on the railway, which a number of arbitration decisions have sort of noted as an extremely safety sensitive area. And that together was sufficient to support a reasonable suspicion that he was impaired, and therefore that testing the employee was reasonable in this case. And so then the arbitrator moved to the second question, that being whether discipline was warranted, and if it was, to what level. The arbitrator reviewed the applicable law in this area and found that a positive urinalysis test, again, because it doesn't test acute impairment, on its own was insufficient to support discipline. However, if the urinalysis test, when considered with other evidence, can support a suggestion or a finding of impairment, then there is cause to discipline the employee. And so in this case, that evidence was present, including, among other things, the employee's behavior, the employee's admission that he was a regular cannabis user, and that he had used cannabis less than 12 hours before the start of his shift. And so with all those conclusions in mind, and again noting the very safety sensitive nature of the workplace, the arbitrator found that there was cause to dismiss the employee in this case, and therefore upheld the employee's termination. And so drug and alcohol testing is an extremely complicated area of the law, and there's a number of factors that go into whether an employee can test, when they can test, and the discipline resulting from those tests. And so this decision is helpful to the extent that it can be in clarifying when an employee or an employer can test an employee when there's reasonable suspicion to test, and how to handle a positive result flowing from that, including the discipline that might be warranted in that case.
Thank you, Chris. Marco.
So this is an employer-friendly case from our Ontario courts regarding the duty to mitigate and what can result from a circumstance where an employee fails to mitigate. And so at a high level, the duty to mitigate is really a legal obligation that requires an employee who has suffered a termination of employment to take reasonable steps to attempt to find new employment. It requires them to search for comparable employment, not lesser employment per se. And there's a heavy onus on employers to actually prove that a former employee has failed to mitigate their damages. And this heavy onus requires employers to provide evidence that the employee would have found comparable employment had they taken proper steps. And this recent case, Gannon versus Kinsdale Carriers Limited, is really an example of where an employer was able to successfully do just that, to establish that the employee failed to mitigate. And so in this case, the employer was unfortunately forced to close its operations at the end of 2020, the start of the COVID pandemic year, and because of the pandemic. And as a result, it terminated all of its employees, including the plaintiff in this case, who had been employed for 23 years. Upon termination, the employee's duties included office clerk duties and accounts receivable. And in 2015, they were also, their job title changed to dispatcher. And the employee ultimately commenced a wrongful dismissal action seeking 22 months of reasonable notice. And the employer took the position that the employee had ultimately failed to mitigate their damages. And their evidence to establish that the employee had failed to do so was that upon termination, the owner of this business actually had reached out and made efforts to find all of its former employees comparable positions. And for this particular plaintiff, this employee, the owner actually reached out to another company, in this case, Zare Transport Limited, about potential employment for the employee. The employee interviewed with Zare, but ultimately decided they were not interested in the position despite being offered comparable employment with that alternate employer, and decided to instead take online bookkeeping courses and pursue other opportunities. In the end, the employee had suggested that what they were offered from Zaire was not actually comparable because it focused primarily on these dispatcher duties versus some of the other duties that were part of her role with her prior employer. And the court disagreed and actually sided with the employer. And the quote here at the end of the slide is something that I appreciate from our courts. And it says that while the plaintiff wanted to see what's out there and pursue online courses, it shouldn't fall on the defendant, employer in this case, to fund her educational pursuits. And so the takeaway here is one of the best ways for an employer to lessen the cost of termination, which seems to keep going up and up, as we're seeing in some decisions coming out of our courts, is to actually help an employee get a job and provide them with opportunities, whether it be comparable job opportunities post-termination, in advance of that reaching out to other employers. And so employers may want to consider actually sending employees job leads in a timely fashion, not just at a later stage where we're at a trial or during examinations for discoveries. And so taking that step to help the employee actually find alternate employment and move on to a different employer might actually help lessen the cost and also allow them to move out on their way and hopefully avoid what could sometimes be costly litigation. So it's just a good example of the duty to mitigate and what a case that looks like where an individual has not actually properly mitigated.
And Marco, this is an Ontario case, but the principle of mitigation applies across the country, doesn't it?
That's correct. It does.
Interesting case, and there's all sorts of, as you said, practical ways of trying to assist an employee to mitigate. One of which includes reference letters. Like, I know there's views of you about providing reference letters, and but I think we have a general bias. If you can, the more positive the reference letter you can provide, within reason and justification, the more likely that employee can find a job and you lessen your damages. And in Canada, there's very, very little litigation around libel and slander coming out of, and defamation coming out of reference letters, unlike maybe the US, for example. So the reluctance to provide reference letters in Canada, maybe it's something that employers ought to overcome a little bit more, because it's to their benefit when you've got these, as you said, the expansion of reasonable notice and termination entitlements for employees. It seems to just go up and up every year without any particular logic.
Yeah, no, that's exactly right. And I don't think the legal landscape around reference letters, to your point, in Canada is where it is in the US. And so the opportunity where you can actually help them bridge that gap to find new employment, and the faster they can do so, the less liability and cost there is on you as the employer.
Okay, so we've got about 12 minutes left. I think we're on track. So we've got a couple more cases to address, and then we can finish up with the immigration section. So Jessica, I think we're on to you, I believe. Termination clause.
Yeah, thanks, Tim. So unfortunately, this case is not helpful for employers like Marco's case, but we continue to see the courts take issue with many of the termination provisions that are being litigated these days, and this is just another case to add to the list. So in Dufault, the Ontario Superior Court found on a summary judgment motion that the termination without cause provision of a fixed term employment contract was unenforceable. And the most notable part of that is because of the language in the termination provision that provided that the employer could terminate at any time and in its sole discretion. So let's unpack that a little bit and dive into the facts. So Ms. Dufault was employed by the township pursuant to the fixed term contract that we mentioned. With about 100 or so weeks remaining on the contractual term, her employment was terminated by the township without cause, and the township provided her with 2 weeks termination pay and benefit continuance. Ms. Dufault sued the township for wrongful dismissal and asserted that the termination provisions in the fixed term agreement were unenforceable. And the termination provision, like I said, at issue, the key part of it and what caught a lot of our employment lawyers' attention was the fact that the court found language that said at any time and the township's sole discretion to be the main issue. So Unpacking that a little bit more, there were three reasons that the court found unenforceable. So first, the for-cause provision was unenforceable because it purported to allow the township to terminate the employee's employment without paying their minimum statutory entitlements using a for-cause standard that's broader than the Employment Standards Act. And that's something that we've seen in the case law before, but again, the court noting that in its decision. The termination without cause provision, the court also took issue with that because it provided that the employee would only be paid their base salary over the statutory notice period. And the court found that, that was contrary to the Employment Standards Act because the Employment Standards Act actually requires that an employee be paid their regular wages over the notice period. And regular wages includes vacation pay, which the provision did not contemplate by only providing for the payment of base salary. And finally, what's most notable about this case and what's really catching people's eye with this is that the termination without cause provision also permitted the employer to terminate the employee without cause in its sole discretion at any time. And the court noted that the Employment Standards Act prohibits an employer from terminating an employee at the conclusion of an employee's leave or in reprisal for attempting to exercise a right under the Employment Standards Act. So the court noted that from its perspective, an employer actually does not have an unfettered discretion to terminate an employee at any time. And as a result of that, the use of the language the court held to contravene the Employment Standards Act. And so the court awarded the remaining 101 weeks of the contractual term. So, a couple of takeaways from this case, going back to your termination provisions and looking at the language and seeing if you now have to amend to address the issues that the court has found as a result of this case. One thing to keep in mind is that this case, I believe, is being appealed. So we'll have to see what the Court of Appeal has to say about this. But that being said, this is one case that suggests that we should go back and see if revisions need to be made, and to ensure that you're doing these checks regularly with respect to your termination provisions to make sure that they're reflective of recent changes, and also to note that if you do amend existing employment agreements, that generally speaking, fresh consideration has to be provided to an employee. So just a quick update with respect to another termination clause case.
Yep, thanks, Jess. Yeah, the good news, I suppose, is it's being appealed.
Mm-hmm.
And so TBD on that. Maybe the next Mondac webinar we'll be able to give an update. Let's turn over to Emily in Quebec about Supreme Court decisions.
Yes, thanks, Tim. My name is Émilie Thibault. I'm a lawyer at the Montreal office, and I will be discussing this employer-friendly decision that was very recently rendered by the Supreme Court of Canada. Actually, it was rendered last Friday. And while I wouldn't qualify this decision as a turning point in the labor relations landscape, I think it's a fair statement to say that this decision brought some much needed validation regarding the impossibility for first-line managers to unionize under the Quebec Labor Code. The facts underlying this decision actually commenced 15 years ago. So in 2009, the Association des cadres de la Société des casinos du Québec attempted to certify supervisors under the Quebec Labor Code. For context, the association represented at the time 70% of the operation managers. An interesting fact of this case is that the employer involved in the certification process was the Société des Casinos, which translates in English into Quebec Society of Casinos, and it is an entity that runs the 4 largest casinos in the province of Quebec and is a subsidiary of l'Auto-Québec, which is a governmental corporation that is responsible for all gambling operations across the province. So the operation supervisors in questions are the employer's first-line managers, And it was eventually shown in evidence that there are 5 levels of management at the employer. The association was at first successful in its requests. The Administrative Labor Tribunal then found that the exclusion contemplated in the employee definition of the Quebec Labor Code violated the freedom of association. The exclusion provided that manager, superintendent, foreman, or representative of the employer in his relations with his employees were not deemed to be employees. Of course, the employer filed an application for judicial review before the Quebec Superior Court. This decision ultimately resulted in overturning the first decision of the Administrative Labor Tribunal. As expected, the association appealed this decision. The Court of Appeal granted the appeal. And what was bound to happen is that this case went all the way up to the Supreme Court of Canada. For those who are less familiar with the Canadian legal system, I'm happy to confirm that Supreme Court of Canada is the highest court in the judicial system of Canada. I will now walk you through the reasoning behind this final judgment, putting an end to a long judicial saga that Quebec lawyers have been following. So first, the Supreme Court discussed at length the applicable tests and threshold to ascertain whether there was an infringement to the freedom of association right. And it clarified in this context that substantial interference is the threshold for proving positive freedom claims, and that such assessment involves a 2-step test. With regards to this first step, the court found that the activities that the operation supervisors seek to engage do effectively fall within the scope of freedom of association as protected under the Canadian Charter and also the Quebec Charter. In other words, the association's claims does involve protected activities, which are to make collective representations to the employer and to have those representations considered in good faith. However, the court ultimately found that this exclusion, in purpose of effect or in effect, does not substantially interfere with the operation manager's associational rights. In assessing the effects in of itself, the courts considered that the operations supervisors formed an association and were recognized voluntarily by the employer as their representative association. The operations supervisors successfully negotiated a memorandum of understanding with the employer outlining collaboration on workplace issues. The employer agreed to consult with the association before making changes to working conditions. Furthermore, the employer agreed to facilitate union activities, including collecting union dues and releasing representatives for meetings. And so, although the record showed that the employer has neglected to properly respect this memorandum at times, the association could nonetheless seek remedies in court should there be any violation of the memorandum. Given these facts, the court concluded that the operation managers, through the association, could associate and bargain with their employer effectively. The court also emphasized, and I think this section is very interesting, in saying that the right to meaningful collective bargaining does not guarantee access to a particular model of labor relations. The court also outlined, in respect of the exclusion from the definition of employee under the Quebec Labor Code, that it was of course not purported to interfere with managers' associational rights, but rather to distinguish between management and operation hierarchies. And it was also purported to avoid placing managers in a situation of conflict of interest. And finally, to give employers confidence that managers would represent their interests. So in sum, neither in effect or in purpose does this legislative exclusion of first-level managers was deemed to be unlawful. And I think needless to say, employers, McCarthy, we're very happy with this decision. It's a good decision. It's nuanced. It's pragmatic, and I think we can highlight also that decision also has a special place for McCarthy because, well, Tim appeared for the Canadian Association Council for Employers, and I think this was a successful intervention in the end.
All right, thanks, Emily. Yeah, we did have a team on this case.
Yeah, for sure. There were other members.
It was definitely a great result for the firm and for our client. And in terms of the conflict of interest piece and the protection of organizational structure, managers not being able to unionize under labor statutes was extremely important for employers, and it just made sense. So we're glad the result is the way it is. Look, we were very ambitious in our content today, and I think we are now at the end of the line. So I'm going to apologize on behalf of Sarah, for Sarah, or I'm going to apologize to Sarah for not getting to her in this presentation. But the good news is we do have another Mondac seminar coming up. I'm sure you'll get notice of it. Sarah will lead off that presentation with some very topical immigration information, probably maybe even more topical at the time because it'll be leading to the Canadian election where this is a major issue. I think if you go on to our McCarthy website, to the immigration page, you'll see some blogs on some of the stuff that Sarah was going to speak about anyway. But we're going to bring her back and give her some fair airtime. So again, apologize for that. But again, thank you all for participating, panelists, and thank you all for listening. And we'll see you again soon.